Hey everyone, this is Ben from Cut Law. Today we are going to talk about the differences between a tenancy and a license. A tenancy is an agreement between a landlord and a tenant that gives the tenant an exclusive proprietary interest in the property. That means he has a property interest in the property. He has exclusive possession. What is exclusive possession? It means he can exercise the rights of an owner of the land. He's exclusive. He can keep out strangers and even the landlord. He can exclude the landlord from the land. On the other hand, a license is merely a permission from the owner to the licensee to do something on the owner's land, to occupy, but it does not grant a proprietary interest in the property. In other words, a license does not confer exclusive possession on the licensee. Let me give you some examples of licenses. For example, if an overseas friend comes to your house, stays with you for a few days, you are giving your friend a license to occupy your room. Another examples would be hotels. The hotel, there's an implied license to the guest to occupy the hotel. Another example would be this office. I am the tenant of this office. I rent this office from the landlord. I can license this table, part of this table, to someone to occupy. But he does not have exclusive possession because I can kick him out at any time. He is not the tenant. Why is this important? Because many people confuse tenancy agreements and licenses, because sometimes when renting units, it doesn't say tenancy agreement, but it says license agreement. Examples would be stalls at a market, those push carts that you see in shopping malls, and for example, the basement shops at Takashimaya, where it's in the food hall, where there are all these little shops where they sell food. So what happens is that the landlord rents the entire premises to, for example, Takashimaya, and then Takashimaya license out cuts it up, the little stalls to individual owners. So they enter into license agreements. But it's very important to note that for licenses, there is no exclusive possession. A license is merely a permission to occupy. Now, on the topic of license agreements, such license agreements that I've just discussed, for example, a little store, a little space in a shopping center, it's not a bare license, because a bare license can be revoked anytime, can be cancelled. They are usually called fixed term contractual license. There is a fixed term, for example, 6 months, 1 year, and it's a contract. The contract looks like a tenancy agreement, but it is not a tenancy. Why is this important, the difference between a tenancy agreement and a license agreement? Very simple, because Section 52 of the Stamp Duties Act provides that where stamp duty is not paid under a tenancy agreement, the tenancy agreement is inadmissible in court. That means you cannot sue under a tenancy agreement. So if it's a license agreement, usually what happens is that the tenant who licensed out the little piece of premises has already paid stamp duty, so there's no double payment of stamp duty. Although in some cases people want to be kiasu, even though the main tenant has paid stamp duty, the main tenant also makes the licensees pay stamp duty.